Well, good morning, and thank you very much for joining us. I am Yori Folari. Today, my guest is Mr. G.T. Ogunye. That therefore means that it's more likely than not that we will be talking things legal. A fine morning to you.
Good morning.
It's been ages, but I'm delighted to have you on the program. And you know, actually we were working on some other kind of a topic, and then after that, we have to prepare in time. Then the news broke that Nnamdi Kanu had been freed by the courts, and that was, talk about a breaking news item. So there's no way we wouldn't bring that up because he not only freed, let me get the proper terminology from you because you would have followed it. Was he discharged and acquitted of all charges, or are there still some that have to be dealt with?
I know that has become immediately controversial given the interpretation that has been foisted on the judgment of the Supreme Court by the Honorable Attorney General of the Federation, Abubakar Malami, that it's only discharged and not acquitted. Now, he's been discharged and acquitted.
In actual fact?
In actual fact and in law. And how do I explain this? Recall that he was, after some pussyfooting and perambulation and all that, eventually accused of a 15-count charge bordering on terrorism and the likes. And at the trial court, 8 of the 15 counts were struck out for being incompetent.
Okay.
And for disclosing no offenses. And the court then directed that it should be tried on the remaining 7 counts. We then led to the appeal, on which a decision was rendered yesterday by the Court of Appeal, a unanimous decision. And what the Court of Appeal did was to strike out the remaining 7 counts and to tell the trial court that there was no basis for the charge in its entirety to continue any longer. So the counts and the entire charge was struck out by the Court of Appeal, and the criminal defendant, in this case, Nnamdi Kanu, was discharged accordingly. Now, that discharge, did it amount to an acquittal on the charge? Yes. Okay. Why? Because the court had ruled that this charge in its entirety was incompetent and that the trial court had no jurisdiction. The court is not entitled to speculate on whether you still have other offenses that you may charge tomorrow or the day after tomorrow. The court was bound to render a decision on the charge preferred, and the court held that the charge was incompetent and that the trial court had no jurisdiction to try, meaning that the criminal defendant could not be tried any longer on those counts. Now, if it's being argued that, oh, the matter didn't go to trial and so no evidence was led, so the discharge was not on the merit and all that, whether it is on its merit or not, the court has said that as far as those counts were concerned, and as far as that charge was concerned, you can't try. And the Court of Appeal didn't stop at that. The Court of Appeal then went ahead to order a release. Why? The court said, yes, you will try him and he jumped bail. And no appellate court should treat kindly, a fugitive offender jumping bail and not coming to court. Is a very grievous offense. However, the court found that in trying to bring him back to justice, the federal government of Nigeria resorted to illegality.
Okay, that is what lawyers are putting so quaintly, the rendering of Kanu from Kenya to Nigeria.
It was an abduction. That's what the court found. And the court found from the reports of the judgment that the allegation of Kanu's lawyers, the defense attorney, defense counsel, that he was abducted was not denied by the prosecution, meaning that the allegation of abduction is being spirited from Kenya to Nigeria without going through the Interpol mechanism or the Extradition Act, was correct, was not denied. And the Court of Appeal had no choice, therefore, than to accept that version of the narrative as the actual fact of what happened. And since that was a blatant illegality, which was not denied by the federal government, the Court of Appeal held that it was illegal, it was unconstitutional, his being detained was illegal and unconstitutional, and that he should be released. Now, the Attorney General reportedly has said that, oh, this was just an acquittal, not a discharge, not an acquittal, implying, since the latitude of mischief can be wide, that we may hold him back and then appeal, and perhaps brings an application for stay or something to that effect. Or we may hold him back and then scurry to find whether we could have other charges that we're going to frame properly to then arraign him afresh. Either way, the little law that I know says that you cannot hold on to a criminal defendant that has just been discharged by a court because he's not a prisoner of the state as such. He's a prisoner of the court. Because once a criminal defendant is committed to trial, is committed to court, he is either granted bail or denied bail. From that point, he becomes a prisoner of the court. He may be kept in prison, but it is the court that will issue a detention order or warrant, or reproduction warrant, as the case may be, while the trial is going on, and so on and so forth. And so, if that court at the appellate level has given an order that he be released, that means the court that is holding him, or the court on whose authority he is being held, has ordered that he be released. And so the prosecution in that case would not be acting legally and constitutionally to then hold back to the person and say, oh, we still want to bring fresh charges. If he's released by complying with the judgment of the Court of Appeal, and 2 days after his release, they can find him anywhere, and they then say, oh, we didn't act properly or competently the last time because God has found that our charges are not competent. So we are now better than we were before. We now know the law we didn't know before now, and so we have these solid counts that we are going to bring. That's a different matter. But as far as this one is concerned, it's a discharge and acquittal.
Which probably might be what Malami SAN, the Attorney General and Minister of Justice, meant, perhaps, when he was insisting that Kanu's rendition, reading it from here, Kanu's rendition from Kenya, that issues that that predated Kanu's rendition from Kenya are yet to be determined. And he said that government would be exploiting the appropriate legal options and also communicate the same to us, but not to us, he said, to the public.
To the Nigerian people, yeah, the
So the point that you've sort of explained for us, that is what Malami SAN is saying, that, sorry, he was discharged, not acquitted. And, well, you've also said that perhaps there's some leeway in what he was saying.
I'm saying that he's wrong, that his interpretation is forced. I'm contending that this an acquittal. Because you brought the prosecution, the federal government of Nigeria, the Attorney General of the Federation, brought a charge of many counts. Some of these counts were struck out, 8 of them in the court below. 7 were similarly struck out by the Court of Appeal yesterday. And then the Court of Appeal held that the entire charge was incompetent and that the trial court, lacked jurisdiction. My contention is that since there are no other charges for now, what the court has said is that you cannot try him on these charges, acquitted. And as far as those incompetent charges or counts are concerned, he's been acquitted.
And so you can't. Is that what you lawyers call double jeopardy?
You cannot
go back.
You can't go back and try him on the same counts.
We've done some more homework.
And all that. You can now go back And if you like, you can then bring new counts that are different from the one you framed earlier, which have been rendered incompetent. You can't bring those charges, for example, you can't bring those counts as they were before. It's not verbal, the same content, and say you want to try it all over again. You may go back and then say, oh, we made mistakes before in framing the charges. The court has found that these counts disclosed no offenses. So we now want to bring counts that disclose offenses. You may do that, but as far as this counts concerned, you cannot, try them. Perhaps the only context in which what the Attorney General is saying, Honorable Attorney General is saying, it makes any sense that, there has not been a full-blown trial yet, and it's not been adjudged not guilty. Therefore, we're still permitted by law to bring good, quote-unquote, counts or a good charge and then try him on that basis. That may be what he's trying to say.
It possibly might be, because the final sentence in the statement that was released by his publicity person was that the federal government will consider all available options open to us on the judgment on rendition while pursuing determination of pre-rendition issues. So let that be as it is. It's interesting that this has come out this way. I don't know that many people, apart from Kanu's lawyers, and maybe would have expected it like this. It's a sort of a wholesale kind of a pronouncement from the bench. But if it hadn't gone this way, perhaps some people might have been talking about the whole question of judicial reform. We need judicial reform in this country and all of that. So I was going to ask, as a coming from this whole area, Justice ARIWOOLA, the new Supreme Court judge, yes, because he's fresh in the Supreme Court, it probably will bring again the whole idea of judicial reform. So I wanted to ask you, with his coming, do you think that we can say the question of judicial reform has come center stage? Now, I ask that question against the backdrop of it being said that judicial reforms, wherever they happen, anywhere in the world, are usually part of a larger kind of reform, or maybe political reform, maybe judicial reform. So are you optimistic that Justice ARIWOOLA'S coming gives us an opportunity to do what lawyers have been asking for quite frankly, decades, a sort of a wholesale judicial reform?
Yeah, I want to say so, but let me just say this. The judiciary is the third arm of government, and it's an important institution of a democratic society. So the judiciary does not belong to lawyers alone. Indeed, it doesn't service lawyers alone or judges alone. So it services the polity, the citizens, the entire country. So it's a very important arm of government, and it's a very important institution. And that's situated. The issue of judicial reform, therefore, is not an issue for a CJN alone that has just come to the saddle as a Chief Justice of Nigeria. Of course, he occupies a very important, pivotal platform, preeminent platform. He's at the apex of the judiciary, and therefore is in a position to drive the issue of judicial reform. But the point has to be made at the outset that the issue of judicial reform is not the business of a CJN alone. However, it is true to say that while a CJN, the Office of the Chief Justice of the Federation, not being an elective one, does not have the opportunity to campaign and hold out campaign promises. Elect me as a CJN. Once I'm elected, this is what I'm going to do, this is what I'm going to do. In spite of the fact that he doesn't have that kind of opportunity, it is presumed that because he's a seasoned judicial officer before you get to that level. He or she, now he, because we talk about gentlemen in the profession, must know the problems and the challenges besetting the institution. And having known all these problems and having been part of the decision making at a level, either as a court, a trial court, a lower bench, high court judge, sitting alone, taking decision of life and death, you know, as a judge, or in a court of appeal as a part of a panel, or a presiding justice of the court of appeal division, in which case is taking administrative decision in the judiciary, not just rendering judgment in a panel or as a part of a panel, or at the level of the Supreme Court, where, you know, you will have been a member of the NJC and all that before you ultimately became the CJN. Since he's seen it all, he's in a position to understand the problems. And if he's reform-minded and he's not conservative, he's in a position to drive reforms. Because when you're talking about judicial reform, basically, you're talking about those reforms in the judiciary that will make the judiciary to be better in doing its job, in winning the trust of the people, because justice must not only be done, but must be seen to have been done. The people must have confidence in the judiciary. Judges must be above board like Caesar's wife. The issue of ethics must be held sacrosanct, and so on and so forth. It must be a corruption-free judiciary, etc., etc. Yes, these issues are there, but those reforms cannot be carried out by judges alone, including the issue of remuneration. And there's no provision for self-remuneration here, in which case judges will just increase their salaries, etc., which is one of the problems. So the judiciary will still have to rely on the two other branches of government, the legislature, those who draft laws, and then the executive, those who execute laws, those who talk about votes. The judiciary can make an appeal to the legislature for the votes to the judiciary, for example, but they don't self-allocate votes, budget to themselves. So the legislature will have to be there, and so on and so forth. So if you want to carry out reform, for example, in terms of infrastructure reform, just as an example, and the CJN, his NJC, all other judges agree and say that we need this kind of money to put up this kind of structure. You know, we want to automate all the courts in Nigeria. We want to digitize everything and all that. They will still have to go to the legislature to appropriate money. So some of the issues of the reforms cannot be dealt with by the judiciary exclusively. And so it's something that is collegiate, if you ask me, although the judiciary will have to lead the issue of that reform, not to forget the role of the bar itself. Because again, judicial officers dispense justice, they sit. Lawyers go to court. They see the fault lines. Judges may not see them separate, but they see the fault lines. And they are also in a position, acting through their association, to then point out the issue of a critical issue of judicial reforms that have to be embarked upon. So I agree that because it is usual, once somebody just gets to the office, the thing is that, what are you going to achieve in this office? You are in this office as a CJN, not just to preside over the court, not just to set up panels at the Supreme Court, your colleagues, that will determine cases. No, but in terms of judicial policy, in terms of judicial reform, what is the stamp you're going to bring? That people then said, the ARIWOOLA'S Supreme Court, this is what happened during that period.
You know,
For example,
his tenure.
For example, when Honorable Justice Ibrahim Tanko was living, one of the allegations, and I'm not just saying this to not allow his sleeping dogs to lie, one of the allegations was that the Supreme Court rules, which last amended in 1995 or so, were due for amendment because a number of things keep coming. We've seen, for example, that during the COVID era, there was a new regime, practice directions were being brought and all that, the lower courts, to regulate how the courts will conduct cases and all that. So we now have a situation whereby evidence could be taken visually, via Zoom and all that, that kind of thing. That the rules for 2 years were drafted. The former CJN was to ensure that the rules were then promulgated, so to speak, because it's the duty of the CJN to issue the rules of court and all that. And for 2 years, nothing got done. So once he gets here now, confirmed, we then say, look, let's look at the rules. What do we need to do in the next 2 months? Things like that.
Which is why you said if he is reform-minded, but then again, if he's conservative, meaning that, look, this thing has been coming like this, let's not mess with it, let's not change it, because it's institutional. So it depends, as you put it. If, reform-minded, then there might be an opportunity. Of course, you've also subjected to the limitation of bearing in mind that the judiciary on its own cannot do it because you still need other people. Maybe to put you on the spot then, since you've been working with the judiciary, the court systems, you've been presenting cases and all of that, and you know most of these justices. What's your impression of Honorable Justice ARIWOOLA? Do you see him? How do you see him as a legal officer? Conservative, reform-minded?
I see him as a brilliant mind and a good jurist who understands the historical duty that he has to perform. Now, you recall that the former CJN didn't leave according to his retirement age. If he had not left the way he left, we won't be having him as the CJN. And his retirement from the bench comes up in 2024 from the records. And so this 2022.
That is Supreme Court judges, they retire at 70.
At 70. So, he was born in 1954, according to records, not 58, that is earlier speculated. And so by 2024, November 11 or thereabout, he will have attained the age of 70 and he will have to retire. Therefore, he has about just 2 years to do all he has to do to put his stamp on the call to duty at the Supreme Court. So I see him as a jurist who is a brilliant man, who understands the issue. I won't call him a judicial activist.
Okay.
Or a radical jurist. But his labeling may not help. He understands the issue. His judgment's very sound. And since he understands the issue, particularly what ails the Supreme Court, judiciary, is in a position to embark on these reforms that we're talking about.
Okay.
Which we've seen some reluctance before now to have put on the table. For example, I'll just give you some example. In the last, since May, 3 justices of the Supreme Court had left. Since May this year. Justice Ejembi, Eko, Honorable Justice Mary Odili, and then the CJN, the former CJN, who left. And so the court number is reduced to 14 right now, 14 justices. The Constitution says that the number will be up to 21.
Okay.
There has not been an amendment of that provision. And I'm not suggesting that that provision should be amended to escalate the number. But what we've seen since 1999 is that we've never had the full complement of the number. The implication of that is that currently at 14 justices, they can only have 2 constitutional cases panel, meaning 7-7. If it is ordinary appeals, they can only have 2. Being 14, they will have to be 15 to have 3 panels of 5-5-5. What does that mean? That means, for example, that from the human capability and the human capacity perspective, these justices, 14 of them, that have been called upon to take on appeals from 20 divisions of the Court of Appeal, and who are also being called upon to take constitutional cases brought under the jurisdiction of the Supreme Court, the ordinary jurisdiction, not the appellate jurisdiction, all those state, federal government cases, and so on and so forth, are not in a position to deal with all these cases, as they wish to deal with them. It's not possible. That's why appeal linger in the Supreme Court for 3, 4, 5 years. Ordinary appeals. All the other cases, political cases, are fast, understandably. But ordinary appeals suffer. And so a lot of suggestions have been made about how to deal with that. Some people have used the term unbundling the Supreme Court. I think that was Keyamo that used that term when it was being confirmed for a ministerial position the last time, Professor Keyamo, Senator of Nigeria. I will use that term. The thing is not about unbundling the Supreme Court. What to do is to refederalize the judiciary. When people talk about decentralizing power in Nigeria, people just assume it is only legislative power, go to the bloated, over-bloated legislative list. So shed that list and so distribute to the state and so on and so forth. Or executive powers alone. Oh, police, state police. No. Judicial powers will also have to be decentralized.
Okay. I'm going to come back so that you can continue on this. And thank you very much for giving us this sort of very, very highly informed overview of what's going on within the judicial system, and especially as it relates to the question that we're asking, that does Justice ARIWOOLA'S arrival in the seat, does it bring to the fore the issues of judicial reform? We'll take a break now. Please stay with us. When we come back, of course, you'll be able to call in and ask questions as well, or make observations or comments with Mr. G.T. Ogunye in studio here. Stay with us, please. Okay, welcome back, and we're having this conversation with Mr. G.T. Ogunye, constitutional lawyer, and we're looking at the prospect of a possible judicial reform, gaining pace as a result of the arrival of Justice ARIWOOLA. But, G.T. has commented on that and has sort of put some guards, that it's not a thing that the lawyers, the law, the legal system itself entirely and exclusively can deal with. There are other aspects of government and all of that. But, we started off, the phones are open now. Indeed, if you wanted to add anything or maybe make inquiries, you could go ahead and do so. We started off because the news broke of Nnamdi Kanu being quite frankly, released. And let me just go back there again. Is he a free man now? I mean, as a result of the pronouncements from court, could he walk home and that's that until they have anything else they want to present?
Man is born free, but forever in chains. I think that I'm paraphrasing somewhat. I don't have information that has been released.
Okay.
The usual attitude of state authorities when it gets to the issue of securing release of person like this. First, they say, yes, we are in court. Yes, there was another, but the order had not been served on us. So that they'll be scratching their head on how do we deal with this unexpected, except it is expected, right?
Then they would have had a
they would
position
just
prepared.
prepared and all that. So then the next thing is, okay, yes, the order has been served on us. We are looking at it. The SSS, the detaining authority now can say that, no, we are not party to the case, the federal government of Nigeria, so we will obey the order as advised by the Attorney General. So the Attorney General represents the state. So once the Attorney General, directs us or advises us, we'll comply. And so maybe 2-3 days then, since we've been promised that they're going to, take some steps, we'll then see what they want to take. But the inclination from the statement is an intention to hold on to the subject while they will take some steps. But that is if they didn't expect the release. Because the release could indeed come as a kind of deus ex machina, something that just resolves something that has been gathering storm. Don't forget that Kanu, the same Kanu, defiant as ever, wrote a letter recently to the president. It was reported in the papers through his lawyers, appealing to the president to release him. That was a new dimension. That was a new disposition of Kanu, that we didn't see before, right? And so we would not know, if there were some quid pro quo. I wouldn't know. And I'm not suggesting that anyway, But that was in the news, and now this. So if there was indeed an expectation that would be released and that this will help douse tension and help manage the trouble in the Southeast, the president always telling interveners from the Southeast that it is in the hands of the court, at least on 2 occasions now. I think that we may see a release later today or tomorrow. But if it's not been expected and the state wants to still do something, they may hold on to him. But that, as I've stated categorically here, will be illegal because the Court of Appeal was very categorical. The court didn't only treat the issue of the incompetence of the charge. And it was far-reaching. The court commented on the abduction from Kenya to Nigeria. And that's the point. If you're going to enforce the law, you better keep within the boundaries of law. You cannot use illegality to cure illegality. Of course, it's arguable that some people may, pontificate and then say, what are you talking about? What are these courts even saying? Somebody jumped bail. Is that legal? Was that right?
Indeed.
So the state has now gone to get him. You are now accusing the state of abduction, of violating his right. What kind of justice system do we have? But, I don't second-guess the court. The court has made a pronouncement. If the federal government of Nigeria says that the court is wrong, they may appeal, but so far they've not done so.
They've not done so far. And I was going to ask, theoretically, what are the options open? Well, Malami SAN, the Honorable Attorney General, has said that they will be exploring options, which suggests that they're not, he as the judicial officer, is that right? Is he a judicial officer?
He's not a judicial officer.
What is he properly?
He's a law officer.
He as a
He's
law
the chief law
officer
of the Federation.
Of the Federation.
While the CJN is the chief judicial officer of the Federation.
Okay. So the chief law officer is clearly not happy with the outcome of events. That is why he's saying that.
The immediacy of his commentaries suggests to me that he was taken aback and I was not happy.
If he was taken aback, again, let me put you on the spot. You're a legal expert, a legal mind yourself. Did you see it coming? Were you surprised that?
I wasn't. Look, okay. The case, and we can make this comment now because the case is dead now. Temporarily, the case is dead. So it's not sub judice any longer. It's dead, and we can therefore make this comment. Even if it is sub judice, in the public interest, we can make comment, but we cannot prejudge or predetermine the matter and say that this is how the matter will go. But let me say this. You have a 15-count charge, and the majority of the counts, 8 of them, were struck out by the trial court. What does that tell you? That tells me that the counts were wobbling. They were not on a solid legal wicket, right? And so the Court of Appeal merely helped the counts by striking out the remainder and burying the charges altogether. So if you take it from the point of view that 8 of the counts have been struck out earlier by a court sitting alone, now that the matter was before a trial court of 3 justices, one could logically expect or anticipate that the remainder of the charges will be struck out. That's number one. Number two, the Court of Appeal, in its decision, and we read it in the report, stated that whereas Kanu's counsel alleged that Kanu was abducted and that his right was violated, and he was brought within jurisdiction without exploiting the Extradition Act provisions or the Interpol mechanism of arresting fugitive offenders, the federal government didn't have a riposte. They didn't deny in the proceedings. They didn't deny the allegation. And so
was that
facts not denied
Yes.
are deemed admitted and are deemed as proven. And so the court founded on that and rendered a decision. Look, there has been a decision that, been cited over time and all, and that's the Asaru Dokubo's case, when, some people say that anytime the issue of obeying the rule of law is an issue, they said, the security of the country trumps the issue of rule of law and all that. That's not how the court put it. In that case, the allegations against Dokubo, and it's in the report, treason, everything and all that. And his lawyer didn't deny. As a mark of revolutionary stardom, you can say, yes, I did it and all that. But when you then get to court and you are asking for bail and you are accused of treason and there are facts stating that you are a very dangerous criminal defendant, if you are released and you don't deny it because you are a revolutionary superstar, it has legal implications. The court will find on the facts.
Because the denial was not made.
And so the court then said, we will be a serious-minded court. These allegations were there, and the one is denied. And you say that bail is a constitutional right. So, yes, the accused is still presumed innocent. He should be released. No, we're not going to release him.
Why?
Right? So, denial is, and that's why I said that for me, when the decision was rendered yesterday, I wasn't expecting an immediate reaction from the Attorney General. Okay. I was expecting more sobriety because the decision that was rendered and the one rendered earlier, with due respect to the Honorable Attorney General and the federal government of Nigeria and their team, was not a celebration or vindication or veneration of the Philadelphian advocacy of Kanu's lawyer. It was more of an indictment. The federal government that after all this hula baloo, with all the security situation in the Southeast, people being killed, soldiers, and all that, the hate crime. Look, during the NSAS crisis, and that's a sad reminder, somebody somewhere was making pronouncement, teleguiding people, making international broadcast on who should be burnt and who should be killed. That's an offense committed in this country. And Lagos State government is not exploring the issue of possibility of investigation and trial of that person. So you brought counts, and the counts were found incompetent. Mm-hmm. What do you want the court to do? So will you accuse the court of taking bribe or what? Or the court doesn't want to help you fight insecurity or terrorism So it's an indictment. So I expect sobriety on the part of the office of the Attorney General. Why should the court tell us and all that? Rather than being jumpy, with prime respect, and then say, oh, we are exploring that. I don't expect that. So it's a very serious thing. I'm not saying that every charge that is brought to court is bound to succeed, but the decision to prosecute is a weighty decision.
You know what
the Attorney General of the Federation or the Attorney General of the state is a master of himself. The law says so. It cannot be teleguided. He's the final authority on it. He takes the decision to prosecute or to withdraw prosecution, to file a nollie, albeit in the public interest. Mm-hmm. So it's a very weighty responsibility. So when you then decide to charge, and you brought 15 counts, 1, 2, 3, 4, 5, none is found competent. What does that tell you?
That's a real problem. And as you were saying, he's the chief law officer, which from the point of view of most ordinary members of the public will mean that he has to be an expert in law. So how...
I believe he's an expert in law.
Indeed.
He's a senior advocate of Nigeria.
And he's a senior advocate of Nigeria.
So there's a presumption.
There's a presumption.
And I'm not going to rebut the presumption.
But the problem for me is that an expert in law, and these things that you've just explained so that the rest of us can understand that, look, if a thing is not if a thing is not denied, then the court is very likely to take that silence for assent.
Exactly.
And how this wasn't seen, which brings me to other conspiracy theories. You might have, if some, not too many, not everybody has the time for social media, but because all sorts of,
things go
on there.
Yeah.
But immediately there have been conspiracy theories that, now we see what's going on. This is to weaken somebody's hand. This is to strengthen somebody's hand. Whereas the court, as you've just explained, will determine, and I think I've known that for ages without being a lawyer, where they say the court is not Father Christmas.
Yes.
You can only deal with what's before it.
And the law does, they also say that it's not a Father Christmas and it doesn't deal with academic issues. It must be a life matter. And so if something was brought and they say, you didn't deny it, you didn't deny it, so what do you expect the court to do? What do you expect the court to do? Indeed, it could have been an argument. Frontally, you could have said that, yes, it happened. But we have to do what we have to do. You can, as a lawyer, you can go to the law of evidence and say, for example, in the law of evidence, I think section 14, illegally obtained evidence.
Okay.
For example, the law says that you must have a search warrant before you can arrest, before you can, and then you didn't obtain a search warrant, and then you busted a person, you got to the house, and you found exhibits. And so that means you didn't observe the law before you obtained the exhibit. So the exhibit were illegally obtained. But a trial comes, and the defense counsel wants to raise an objection that, no, this exhibit were illegally obtained. The law allows you a window to say that, yes, it's illegally obtained, but this is the reason it must be used. Okay. Because we didn't have the luxury of obtaining it. And so the consequence of rejecting it, outweighs the refusal of the court not to accept it, things like that. So make the argument. But in this case, the court said, you didn't deny, you didn't make comment on how it came in.
And these pronouncements are going to be taken into consideration when the case goes upstairs. These things that you've just been explaining.
Exactly.
No doubt.
Exactly.
They will be taken into consideration.
Exactly. The final court is usually, the final court can overturn the verdict, but usually it doesn't make it a habit or practice, and this is a rule of law, to disturb the findings of two lower courts when there's concurrence. Okay. So when there's concurrence, if there's an assumption at the apex court that it was the right, won't disturb the findings.
Again,
so that's why,
for the non-lawyers among us, among the viewers, concurrence means that there was not even a dissenting one.
That means there is what was found in the lower court concurs with what was found in the Court of Appeal, the intermediate court. So when you then get to the Supreme Court on finding of facts,
that is
are you then asking the court to go and then start, they say, no, if these two courts, two levels of court,
if they concur
on the same position, won't make it a habit to disturb the finding. So that's why when you conducting cases and issues are being raised at trial stage, at appellate stage, and there are direct allegations, you have to respond to them. If you don't respond to them and it goes in, you can't then go upstairs, further upstairs at the apex court and start saying that, yes, I didn't deny, I was sleeping, or I didn't know. So you can't say all those things.
Now, almost in almost in conclusion now. Yeah. When you look at the situation now, Nnamdi Kanu has been discharged and acquitted, as you put it. But this, Honorable Attorney General says,
as per the charge, he's an acquitter for me.
For you,
yes.
But the Attorney General's statement says he's been discharged. Okay, well, I have to concede that, but not acquitted.
Except that there is no other charge against which you should text whether he can be acquitted or not. That's the point. So there is no other charge now. That's the charge. The Attorney General may be thinking of inventing a charge tomorrow, but as of today, there is no other pending charge. That's why I call this one an acquitter. When you are saying that it's not been acquitted, do you have any other charges? Do you have any other pending cases elsewhere? None.
And you're not going to be allowed to bring charges,
the same
charges.
The way you frame them, you cannot bring them like that. You can't.
Well, it's, without being a lawyer, it's one can understand it from the clarity that you bring to the issue. But the comment that I can make is that, okay, Nnamdi Kanu, Mazi Nnamdi Kanu, MNK, I think that's one of the, he is who...
Initials or acronym?
Yes. He is who he is. He's a revolutionary. He's a radical. He's done all the things that you were saying. He's broadcast things. He's not said kind things about Nigeria outside. Now, all of that, the Nigerian state might take issues with that. But the court still went ahead, in spite of all of that, and said that, well, this citizen of the country, as far as we are concerned, he must be subject to the law, and the laws as they stand and the case that you are making, you've not done a good enough job at all. And we can't do anything with this but to discharge. Let me just leave the business alone, but to discharge him. That very discharge aspect of it, it really does suggest perhaps a hope for the judicial, because no matter whose ox is God, no matter who may not be happy with this particular decision, the court probably can explain why it went the way it went. That is without prejudice to the fact that Nigeria has been called all sorts of unsavory names, that you don't expect of a national. But then he's saying that I'm not too sure this whole matter of the nationality is another question altogether. But the court sees him as a Nigerian, and that's why he's brought under Nigerian law, and has now decided in his favor. That is...
he was charged as a Nigerian, regardless of what he believes he is.
Yes.
And he defended himself as a Nigerian. Every affidavit that is deposed in court, the opening paragraph, perhaps, Nnamdi Kanu, of Nigerian citizen, Christian, and all that, he put Nigerian citizen. He wouldn't have put a Biafran citizen or a UK citizen. I'm sure. Yes. I've not seen those processes, but I'm sure.
Yes.
So he defended the charge as a Nigerian, in spite of all the razzmatazz and all that. And when he was writing to the president for reconsideration of his matter, he wrote as a Nigerian citizen to the Nigerian president. He didn't write to the Biafran president. He didn't write to the UK, whatever. Right? So let's be clear. Therefore, he's entitled. I have not been stripped of his citizenship, and he cannot be stripped because he was born here in Nigeria, Nigerian parents. So he's not a naturalized Nigerian, and therefore he cannot be denied of his citizenship and the citizenship rights. So what the court has said is that, regardless of how egregious an offense somebody has committed, is allegedly, even when he's being tried, he's still entitled to the protection of the law. And that's what has been demonstrated. And that's what has been demonstrated. So what the Court of Appeal has done, for me, is a vindication of the rule of law, but it also tells us that all of us as Nigerians, because for me this is not, and this shouldn't be a celebration like Kanu and all that. There are too many deaths in Nigeria. In the Southeast, everywhere.
Okay. You know,
people are being killed, including soldiers, policemen, civilians. Life has become very difficult.
okay.
Commerce is not flowing. So we need to sit back and say, perhaps use this court release to say, let de-escalate.
Okay.
How can we resolve
We're gonna have
all
to-
these disputes?
we're gonna have
and
to
then
leave it here.
have a more prosperous society.
Well, thank you very much, G.T. Ogunye, constitutional lawyer. We certainly have had the benefit of some of the explanations that you've given.
It's
We
my
thank
pleasure.
you once again.
It's my pleasure.
A real pleasure.
Yeah.
Okay, then. So that's Mr. G.T. Ogunye, constitutional lawyer. We touched on two main subjects. One, the prospect of ARIWOOLA'S coming, you know, giving fillip to the whole matter about judicial reform. He's commented on that. And indeed, Mazi Nnamdi Kanu giving his freedom, although the Attorney General says that they'll be exploring all possible legal options in the matter. So that's our program today. Please join us on Monday for a fresh edition. I am Yori Folarin. Bye-bye for now.